There's no right answer to aerial property rights. There's no right answer to what local drone ordinances ought to be. There's no right answer for what the scope of federal or state preemption of drone laws might be. There just isn't. It's going to be a conversation.
You're listening to the Drone Radio Show podcast, the show about drones and the people who use them for business, fun, and research. Hosted by Randy Goers.
Hello, everyone. This is Randy Goers, and welcome to the Drone Radio Show podcast, episode 77. What are some of the current legal issues facing drone operators today? That is the central question posed to today's guest on the Drone Radio Show. Steve Hogan is an attorney with Ausley and McMullen, focusing on commercial drone law since 2012. The firm specializes in assisting clients in obtaining waivers for drone operations. Steve is also the host of Drone Law Today, a weekly podcast that addresses current developments and future trends in drone law. And he's the author of The Drone Revolution: How Robotic Aviation Will Change the World. He's here to talk about current legal issues in the drone industry, why some operators may not want to toss out their Section 333 exemption, privacy and airspace concerns, and state and local regulations in the drone industry. Let's pick up the interview where I asked Steve to introduce himself.
Sure, Randy, and thank you so much for having me on here today. You're doing great work on your podcast and everything that you're doing to get good information out there to the people that are trying to make the drone industry happen, to make these things fly. And I'm privileged to be here. My name is Stephen Hogan. I'm an attorney with the Ausley McMullen firm in Tallahassee, Florida. And we've been working with commercial drone companies since 2012. And over that time, we managed to learn a lot about the industry and a lot about the legal issues that are specific to the drone industry. And in order to share that information out there in the world, we launched the Drone Law Today podcast a little bit over a year ago now from where we're sitting here recording. And that's been a wonderful way to get to know more people in the industry and to see other people that are out there fighting the good fight in the podcast world like yourself. So I appreciate being on here today.
It's great that you're here, Steve. Can we start by having you give us an overview of what's been happening in the drone industry from a legal perspective?
Oh, yes. And I tell you, I've said this pretty often, that a month in the world of drone law is like a year in any other field of law that you might be able to think of. And that's really been true. Like I say, we jumped in 2012, specifically January 2012 was when our law firm sat down and started looking at the commercial drone industry as something to focus on, as something that we could help with. And of course, the FAA Modernization and Reform Act of 2012 was signed in February of that year, and it's been a roller coaster ever since. And the world has changed completely between then and now. We're recording this toward the end of 2016. My gosh, we will have been working with the industry 5 years come 2017. And in that time, things have changed completely. For one thing, now we have an SUAS rule. And people looking at the Part 107 regs think, all right, we got Part 107. Now I just have a look at Part 107, think about how it works. But, remember, that has only been in place since August of this year. I mean, it's only a couple months old. It's a baby. And what Part 107 actually means and what the waiver process is really going to be and how various drone business models are going to interact with that set of SUAS regs is still to be seen. I mean, any area of law matures and changes over time. That's why they call it a practice, right? But drone law has been this never-ending tidal wave of change, and it's been just something that we've had to surf on top of. The biggest change that I can say is that we've had a lot of change, and now at least we have a rule that will govern most commercial operations on the SUAS side and under 50 pounds. The rules for anything that's over 50 pounds are yet to be written.
As you said, Part 107 is now in effect. What about Section 333? Do we need to be concerned with it?
I would say a qualified yes, and here's why. As we know, before the Part 107 regs came out earlier this year, only a couple months ago from where we sit, the Section 333 process, of course, that was an exemption process that the FAA set up under the law that I mentioned earlier, the 2012, or the FAA Modernization Reform Act of 2012. It had several sections in it. And one of those sections in that law from 2012 was Section 333. And what Section 333 said was it gave the FAA authorization to decide that certain types of drone flights could be conducted safely, even though there was no specific regulation on the books that would tell the general public how to do it safely. So the Section 333 process was set up to create exemptions from what? Exemptions from the rules and regulations that govern manned aircraft flights. Because as we know, the FAA considers drones, even the SUAS ones, even the small ones you can fit in the palm of your hand, considers those to be aircraft under the manned aviation aircraft rules. So the Section 333 exemptions were exemptions from those manned aviation rules. And so all the companies that got Section 333 exemptions, which were about the only practical way you could operate legally, commercially, well, they still have them today. So if you are a holder of a Section 333, if your company was one of the first ones to get that golden ticket for legal commercial operation, you can either fly under your 333, but if you do, make sure you're following all its rules, make sure you're doing the reporting requirements that I believe all of them require, make sure that you have somebody with a manned pilot certificate being the pilot in command, or you can go under Part 107, so you have an option there. And also on a go-forward basis, and I've said I've been testing this too against other practitioners in the area, and nobody has yet told me that I'm wrong, so I'll just keep saying it. Section 333 did not die with the implementation of Part 107, right? I mean, it's still an authorization from Congress and the president, from the federal government, federal law, to the FAA that they can decide that certain flights are safe before regs that would govern that flight otherwise are on the books. And that means that the Section 333 process is still theoretically open for non-SUAS drone flights, unmanned aircraft systems that are 50 pounds or above, right? So something that's not an SUAS. So that process or something similar is definitely going to survive Part 107 until such time as the FAA gets around to writing the regs for the big ones, and who knows when that will come.
If an operator has a Section 333 exemption and they've passed the Part 107 certification test, do they need to inform the FAA that they're no longer operating under their exemption?
That's a good question. And I think it gets to the main oddity that we find ourselves with in the world of drone law. And what I mean by that is this. You can have a type of drone flight, right? Takeoff, flight, landing. And that flight can be wherever it is, whatever the mechanics of it were, doing whatever you're doing, right? But if you do it with a commercial intent, well, then you're in the commercial rules, right? If you do that flight with a hobbyist intent, well, then you're in the hobbyist rules, right? If you're a government entity doing that exact same flight, well, then you're in the government rules, right? So the flight hasn't changed, but the intention of the operation has changed, and that changes the legal significance. So that's a long way of saying that if your intent as an operator is to operate under your 333, then keep track of what you did. Make sure you're doing your flight log however you do it. There's good resources out there, both electronic and paper. I think paper is a better idea than electronic, but I won't pass judgment on what anybody does. But make sure you're taking the time and taking responsibility for documenting what your flights are and what your stated purpose for that flight was and what you were operating under. If you were operating under 107, you want to know each flight that was under that and document the fact that you are complying with those requirements, that you did call your ATC if you needed to because you were close enough to need to do that, et cetera, et cetera. So I think it's a documentation issue on the side of the operator more than a, hey, FAA, this isn't Part 107, it's a 333, because, they don't really know who you are or where you are.
Recognizing that Part 107 is still new, are you aware of any issues or glitches with its rollout to date?
I think one of the biggest practical issues is the trouble that people are running into with getting approval for flying what would be a safe flight, but they're within 5 miles of an airport. And airports, air traffic control, or whoever picks up the phone, whoever's tasked at that airport with dealing with calls from drone operators, they have been extremely inconsistent in the things that they are telling to drone operators and the permissions that they're giving. And that is troubling. It's troubling, but it's probably not surprising to anybody that's been in this game for any amount of time. Case in point, just yesterday, I was giving a talk at a local startup business incubator here in my town, Tallahassee. And there was a drone company that was going to be there, and was going to do a little flight, little demonstration, to the people that were showing up to this talk, and take a picture of everybody that was there. It was going to be great. And I know the company, completely responsible operator. He's been on the podcast on Drone Law Today, to talk about these things. You couldn't ask for a better operator. And, he called up the day before that talk and said to whoever picked up the phone on the hotline, yeah, you're good. Just call the day of. Here's the number. It should be fine. You're good, because the area was within 5 miles of an airport. But the day of, he calls the line and they're like, yeah, we're not in the business. This is literally what they said. Yeah, we're not in the business of approving or denying flights, so you're denied. And so what could you do? What could you do? So we didn't. So we just held up, this is a DJI Phantom, And that was interesting enough, but it actually, the crowd listening to my talk was a bunch of lawyers. So it served as an object lesson of the legal weirdness of this area of law. So I think that's a practical problem that people are running into. I don't have a magic solution to that other than if you can get to know the people working in your local ATC, wherever you happen to be operating, that is the thing to do. Because the better you know them, the better they know you, the better things are going to go for you. And I think that's the best advice I have at this time.
What if somebody wants to do something that's not covered by the Part 107 certification?
When people want to do a flight that's outside the strictures or confines of what 107 allows, for example, beyond visual line of sight, or they want to fly at night, et cetera, et cetera. But of course, we have that waiver process that the FAA set up, which is turning out to be extremely user-friendly. The FAA has been very quick to grant waivers as long as the requester of the waiver is doing it in an intelligent manner and giving the FAA all the information that it needs. I mean, often though, you see people applying for waivers and just saying, well, I want this and this, but they don't say why. And then the FAA says, go back and forth. I mean, that's when a professional can help you, especially if it's something exotic and odd. That process is still maturing. I mean, this has only been out there for a couple months. As these things move forward, that waiver process is going to get more and more streamlined, and people will sort of know what they're dealing with when they look for specific types of waivers.
It seems like things are generally moving along pretty well with the Part 107 process. But an area that seems to be gaining some attention is what's happening at the state level. What do we need to know about state laws?
I know both you and I are here in the great state of Florida, and me being in Tallahassee, Florida, that's our state capital. We have a specific law, a specific statute on the books that does specific things and may impact drone companies in specific ways. And you have laws that are popping up and have popped up all around the country that do similar things. Right now, it's hard for operators to really get a handle on what is going on in whatever state they happen to be operating in. You have two sorts of philosophical approaches that you see popping up around the country. One approach is the approach that Florida has taken, which is I don't have a good catchy word for this, but a philosophy of prohibition, if you will. If you go through a prohibitionary approach, if you will, then your state laws and regulations are going to say what you cannot do with drones. Say, no. And that looks pretty negative on the face of it, right? Let's set that aside for a moment and look at the other sort of thing that you see. And the other philosophy you see is more of a permission-based set of regulations. And Texas is a good example of this, where the Texas drone law and other states that follow this sort of model say, well, hey, you can use drones in this state. You can use them for this, that, and the other thing, right? And there's a whole big list in Texas, a very long list of what you can do with drones, what you're allowed to do with drones. But here's the issue, though. One thing that pops up with that is that when you look at a prohibitionary type of law like Florida has, that looks sort of negative to the drone industry, at least on its face. And when you look at a permission-based drone law like Texas has, that looks very drone-friendly, right? But then there's this weird ambiguity. There's this weird mirror world that pops up, because when you look at the Texas law and you think, well, wait a minute, is this list of things you can do with a drone exclusive? Meaning, if you come up with a drone business idea that's not on the list, are you prohibited from flying in Texas? And the answer to that is nobody knows. But when you look at the prohibition style Maybe that's prohibition style is maybe a little bit too 1920s of a word, but you take my meaning. The more prohibitive approach in Florida, well, if you get a new idea of how to use a drone for a business, something innovative, as long as it's not on the prohibition list, then you kind of know you're good under Florida law. So it's an interesting, I don't really want to call it a dichotomy. I'm running out of adjectives. That's a phenomenon that you're seeing all around the country.
Yeah, and what I've been seeing at the state level is a focus on privacy issues and developing some sort of criteria to protect the privacy of individuals on the ground. What's your take?
It's important to understand what the role of states are here when we're talking about drone regulation. One thing that comes up on my podcast, the Drone Law Today podcast, because it's a drone law podcast specifically, is the question of preemption, right? And just for the benefit of people who may not have heard that word, preemption means that when you have a federal law and a state law on the same subject, right, then the federal law wins. The federal law preempts or not overturns, but takes precedence over the state law. And of course, it gets more complicated at the edges, but that's the main point, right? So when people look at state laws, they're like, whoa, the federal law is going to preempt it. Well, not necessarily. Because the way that I think about it is this, and I've been testing this against other practitioners and scholars in the field, and nobody's told me I'm wrong yet, so I feel pretty comfortable with this conception. And the conception is this: the FAA will have jurisdiction, complete jurisdiction, to determine what a safe drone flight is. All right, they will decide, they will determine, they will tell us what a safe flight is. But states, on the other hand, will have almost unbridled authority to tell people in their state what you can and cannot do with a drone in the context of an otherwise safe flight. And that means that even if you're flying safely, the state can say, well, even though that's a safe flight, because of what you were doing with it, that's illegal. And that is absolutely the framework that will rule the day. And so states have traditionally been the place where privacy is governed. I mean, the federal government doesn't govern privacy. They just don't. And the FAA, to their credit, has not tried to claim jurisdiction over privacy. They've multiple times said privacy is not our deal, y'all, and left that to the states. And I think that's the right decision. And so states have been grappling with this privacy problem because, number one, because it's within their regulatory sphere. And number two, there's something about drones that brings privacy to the fore in ways that other technology just doesn't. And on a recent episode in my podcast, I was talking specifically about the privacy question with one of the leading legal scholars in this area. And we were talking about drones as a privacy catalyst. And what that means is drones are something qualitatively different than the way your computer works or the way you interact with your computer that makes you think about privacy in a different way, makes you think about it in some way that's more visceral than privacy of what data may or may not be being looked at by the NSA over your computer line, right? It's just different that way. For better or for worse, I'm not passing a value judgment on that. It's just kind of the truth of how it's playing out.
There's no consistent definition for what constitutes an invasion of privacy where drones are concerned. Isn't that part of the problem?
That's absolutely right. In fact, take Florida as a case in point. Florida, in its statute, section 934.50, defines a term called a reasonable expectation of privacy. Okay. Now, those words, reasonable expectation of privacy, have significance, have legal significance in the world of search and seizure. Like that's the Fourth Amendment to the Constitution, protecting us from unreasonable search or seizure. And generally, you're protected from unreasonable search and seizure by the state if you have a reasonable expectation of privacy in whatever would have been searched, right? So that term has legal significance. But in Florida's statute, they use those words, but then they define it as something completely different than what it means in the case law. And they define it essentially as if a drone can see something from the sky that you couldn't see from the land, then that's an invasion of my reasonable expectation of privacy. And that's a statutory definition in Florida. That's unique to Florida. I'm not sure as I'm sitting here whether other states have taken that tack, but that's how it is in Florida. And what exactly that means in everyday life under this statute, no litigation has happened under that statute, so we don't really know what the gray areas of that definition are going to mean. And that's a dynamic that's going to be played out in all 50 states.
I also hear people talk about the airspace above their land, that it's an extension of their property, and drones can't operate there. Can you comment on that?
That whole question of aerial property rights is something that is also going to be brand new. And here's why. When we talk about drones as aircraft, okay, that's already weird in the context of the regulations that govern manned aircraft, right? How can a drone be an aircraft if there's nobody in it, when all those regulations and statutes that were written to govern aircraft were written with the assumption that an aircraft is somebody with a person in it, which connotates a certain size, a certain expertise in operation, of a necessity, et cetera, right? That's weird enough. But then we have all this case law that has built up over a generation since aircraft became a significant commercial thing that has defined what airspace property rights actually means in the context of manned aircraft. And all the settled law for a long time has been that no property owner could exclude a manned aircraft from flying over the air above their property. That's what all the cases say. If you have manned aircraft, you get the glide path up, you get the highway in the sky, you get the glide path down, right? And if that interferes with the value of your property, maybe you have a takings claim, or maybe not, depending. And all that's pretty settled law, right? Because it used to be, the thought was that you owned the air above your property all the way up to heaven, and in the land under your property all the way down to hell. I mean, that was the old, really old common law idea. But the introduction of manned aircraft made that have to change, and it changed through litigation. But now, all that case law, if you take it literally, means that you don't have a right to exclude a drone from the airspace above your backyard. And that hits people as patently ridiculous, right? And there's also the authority that the FAA has at least said it has to regulate all airspace, meaning all air above, down to the blade of grass. And that includes your backyard, even if you're flying your drone below the roof line of your house. So that's a real question. Aerial property rights is a real question. And some states have stepped in to try to grapple with this with proposed legislation. There were some things flying around in the state of California that did not ultimately get signed by the governor, but that were grappling with this idea. And that is another idea that is unsettled in the law, and it's going to be unsettled for a while. And it's something that's going to have to be grappled with and dealt with on a state-by-state basis.
You remember about a year ago, there was that guy that shot down a drone as it flew over his property. Was that a property rights issue or a privacy issue, or both?
You talking about the drone slayer?
Yes, I think so.
Well, that particular case is interesting because that scenario that played out, and if people want to Google it, you can Google drone slayer or Boggs versus Meredith. We've had the attorney that's litigating this case in federal court out in Kentucky on the podcast a couple times. His name is James McMullen. And it's an interesting case because you have several things here. You have a drone operator who is operating his drone, and allegedly it went over this other guy's property. And then that guy whips out his shotgun and then shoots several times, misses several times, finally hits it, and then it goes down. Then the drone operator walks over to the guy's property to say, "Hey, man, give me my drone back. You just shot it down." And then the dude whips out a Glock. And then law enforcement came, and the state court judge refused to hold the shooter accountable for the destruction of property. And following that, there was a federal lawsuit filed, and the attorney that's handling that, James McMullen, has filed an action in federal court to get a ruling from a federal judge about whether or not shooting down that drone was equivalent to shooting down a 747. Because remember, drones are aircraft, right? So if you shoot down a drone, you just shot down an aircraft, right? That's a felony, friends. So we'll see what happens with that case.
That brings up an interesting question. In my city, if the branches of my neighbor's tree crosses my fence, I have the right to cut those branches. I can't cut any of the branches on the other side of the fence, but I can cut straight up along my property line as high as I want. So I wonder, if I can cut tree branches that break the property line of my airspace, do I have the authority to knock down a drone that violates that same airspace?
I think it's an interesting question, and I think it's a conversation that needs to be had. And remember, that concept that you bring up of the trees over my property line, I can cut it down. That didn't come out of the air. That didn't just pop out of nowhere. That was a decision that was made by the legal authorities that are relevant to that area to decide that, yes, that is a right and just way to allocate the rights and responsibilities of property. When you have a tree hanging over my yard and, I need to cut it, I can cut it. When you think about drones, you have a similar kind of conversation that has to happen. And it's frankly is happening now. And it's a dynamic conversation. And it's not just a conversation of people talking. It's a conversation of the way that people are acting and interacting with each other. And as those interactions continue, and as people continue to grapple with these problems, we will come to eventually some sort of consensus on, at least in particular localities, particular states at first, and then out from there, what it means to be able to exclude or not drone technology from close airspace to property that you own. And the concept that you bring up, the analogy to cutting down a nuisance type tree is not a bad one. I think it's an interesting place to start the discussion, but a discussion it is, and a discussion it must be. I don't claim to have the best ideas about any of this stuff, and I think it's a set of decisions that need to be made at a local level on a case-by-case basis until we really know what's best.
What do you see as some of the other issues that local governments might need to pay attention to as more drones take flight?
I think the issue of drone ordinances at a local level are going to be huge, because we've seen this pop up all across the country, and I haven't even tried to keep up with it because it's just mind-bogglingly bewildering to attempt. You have various cities saying no drone zone here, no drones here, no drones there. It's generally prohibitive type laws or prohibitive type ordinances rather than pro-drone drones here, And we've been seeing that all across the country. One thing that some states have been doing, and I'm not going to shoot from the hip and just say a state, but there are states that have done this, that have preempted. We used that word earlier, preemption at the federal state level, federal Trump state laws. Well, some states have explicitly preempted at a state level any local drone ordinances and said, any drone ordinances at a local level, no, you can't do that. Okay, we're going to deal with this at a state level, so we know what the law is everywhere in this state. And I think you're going to see that in more and more states because the ordinances just get weird. It's just weird and badly drafted. And I'm not necessarily criticizing the attempt of city or county folks to try to come up with a drone ordinance, because it's frankly bewildering if you're not knee deep in it all the time. We've been doing it almost 5 years now, so it's like, yeah, you can't do that, or that. This is the problem you're going to have with this sort of ordinance. But you see local ordinance saying, well, you have to register your drone with the city. What does that mean? Like, really? Upon whose authority? So it's a problem. But there's real pressure sometimes, depending on the municipality, for the local government officials to do something, especially in the face of the FAA's history of inaction. They've been moving fast in the past year, fast for them. But before then, it was just a whole lot of nothing, a whole lot of foot dragging. And I'm not saying anything that anybody doesn't know. It was extremely slow. There was no action and a lot of uncertainty. And when you have uncertainty in an area of law, then people are going to move to make something certain, at least at a local level. So that's an ongoing issue that we're going to have at the local level.
As 2016 winds down, what do you think the top issues will be for 2017?
I think you're going to see a couple things pop up, and this came out in a recent discussion on Drone Law Today with Tom McMullen of AVSI, which is the national trade organization, the biggest and oldest trade organization for unmanned vehicle systems. And he telegraphed two things that may be coming down the pipeline in 2017, one of which is a potential micro UAS rule, where the FAA would treat things that are very small differently than the things that are sort of up towards that 50-pound demarcation line between SUAS and UAS. Because you and I both know that a 45-pound drone is much different than a 5-pound drone. And they ought to be treated differently from a regulatory perspective just because the safety profile is much different. So that may be coming down the line. And you may also see something happen with beyond visual line of sight or nighttime things, because it doesn't really make sense. Like, everybody wants to fly BVLOS, right? Everybody wants to fly at night. right? And I think you might see some action from the FAA to just get that in a rule rather than giving waivers to everybody and their brother that applies for them. So that's what I see on tap for 2017. We'll see what happens.
And you mentioned it a few times, your Drone Law Today podcast. Can you tell us about it? How long have you been doing it? And why did you jump into the world of podcasting?
Sure. And, it's funny. I tend to mention the podcast when I talk to people because it seems like everybody I know in the industry I've had on. So it's like, oh, yeah, and this guy, no, well, he was on the podcast, so I can give you the link to, our discussion here, et cetera, et cetera. We started it in August of 2016. And just in order to share some of the things that we had learned over time and to combat some of the misinformation out there, because there was a lot of bad information out there. I mean, the FAA is better today about sharing good information, but I mean, half the time, anything you heard from the FAA was essentially a half truth. And it was difficult. And I understand. And when I say half truth, I mean they were giving their position as if it were the only position, and that isn't really true. The FAA is a lot better about things now. It helps that there's actually a rule in place that they can point people to, and they become a lot more user-friendly. So I give Administrator Huerta and the whole FAA UAS team a lot of credit for catching up to where the industry is and taking a leadership role and making things better. But when we started in 2016, we just wanted to share some good information and clear up some misconceptions out there in the world. And it's been a wonderful way to give a platform to the people that are doing great things across the country, especially and specifically in the legal world, because, this area of law is so quickly changing. There's no right answer to almost anything we've just discussed today. There's no right answer to aerial property rights. There's no right answer to what local drone ordinances ought to be. There's no right answer for what the scope of federal or state preemption of drone laws might be. There just isn't. It's going to be a conversation. It's a conversation that has to be had. So what I have been really pleased with is the fact that we've been able to have those conversations in public and grapple with these ideas in real time as things develop. And that's what keeps me doing it. And it's been a very fun thing to experience and to get to know all the members of Drone Law Nation out there that are listening and subscribing to Drone Law Today.
Who is the podcast intended to reach?
It's a legally focused podcast. And when I started it, I thought my intention was to target people who were starting drone businesses, drone startups that wanted to make sense of what they needed to do to get legal. And I definitely have those people in my audience listening in. And what I've also found is that I have a lot of lawyers listening that are trying to help their clients with these things. I have people in academia listening that are grappling with these issues in a scholarly level. And I really appreciate when scholars grapple with these questions, because that means I get the benefit of their thinking rather than having to try to puzzle through these things myself. And we also have members of the insurance community that are out there insuring these things and trying to advise people on how to do things safely. So those are the main categories. I'm sure we have other people that are listening, but that's the main makeup of the audience there.
What have you learned most since doing the podcast?
Well, I've learned how little I know, frankly. I mean, I always learn something new when I have people on. I get the benefit of their experience in talking through these issues. Frankly, when you and I met at AUBSI earlier this year, I learned some things from you. And it's been wonderful to get to know people in this industry that really care about this industry and where it's going. And it's that continual process of learning that keeps me going.
That's great, Steve. Is there anything that we should talk about that I didn't bring up?
I think we covered a lot of ground. I just once again invite your listeners to check out the podcast Drone Law Today and to download a free copy of the book I put out last year, The Drone Revolution, How Robotic Aviation Will Change the World. They can get it for free at dronelawtoday.com/book. And that'll put them on the mailing list if they want to be there to be among the first to hear about the new stuff that we've got coming down the pipe.
That's it for episode 77 of the Drone Radio Show. I hope you enjoyed hearing from Steve Hogan of Ausley and McMullen and getting caught up on the current legal challenges. I want to thank Steve for taking the time to speak with me. If you want more information or want to connect with Steve, check out the website at dronelawyers.com. And please check out Steve's Drone Law Today podcast, where you can stay on top of all the legal questions. You can find the podcast at dronelawtoday.com. If you enjoyed this episode, please leave a positive review on iTunes. It really does help. And as always, I hope you'll listen to more episodes of the Drone Radio Show podcast to hear how others are using drones for business, fun, and research. For the Drone Radio Show, I'm Randy Goers.
This has been the Drone Radio Show podcast. More information on today's show can be found on our website at www.droneradioshow.com. If you're using drone technology for business, fun, or research and would like to share your experience on the show, please visit our website and fill out a guest appearance application. And don't forget to follow us on your favorite social media channels.